Welcome to Bankruptcy Unlocked, your legal path to relief.
Welcome to Bankruptcy Unlocked, your legal path to relief with attorney Andrew Griffin. If you're feeling overwhelmed by debt, you're not alone and you're not without options. Andrew breaks down the bankruptcy process in clear, compassionate terms, helping you understand your rights and take control of your financial future. Let's unlock the path to a fresh start together. I'm your host, John Clements, and today's episode is Bankruptcy and Your Home, What You Need to Know. So first of all, Andrew, hey, welcome back, man.
Thanks for having me back again.
Absolutely. Really curious to dig into this. So my first question for you is, can you keep your home if you file for bankruptcy? And how does that depend on whether it's Chapter 7 or Chapter 13?
Yeah, one of the most common concerns people have when filing for bankruptcy is whether they will be able to keep their home. The answer depends on several factors, including the type of bankruptcy you file, Chapter 7 or Chapter 13. It also includes what's the value of your home and the laws in your state. Let's break it down, how bankruptcy affects your home and how it differs between Chapter 7 and Chapter 13 bankruptcy. In Chapter 7 bankruptcy, a Chapter 7 bankruptcy is often referred to as liquidation bankruptcy. This type of bankruptcy allows individuals to discharge most of their unsecured debts, such as credit card bills and medical debts. However, in exchange for the debt relief, a court-appointed trustee may sell non-exempt property to pay off creditors. But can you keep your home? The short answer is, it depends. In Chapter 7, you may be able to keep your home, but there are few important factors to consider. One of the most important is exemptions. Bankruptcy law allows for certain exemptions that let you keep your property up to a certain value. Most states have exemption laws that allow you to protect your home, but the exact amount you can protect your home varies by state. For example, some states have homestead exemptions that let you protect the full value of your home, while others may only protect a portion of it. If the value of your home is less than the exemption amount in your state, you are likely to keep it. If your home's equity exceeds the exemption amount, the trustee may sell your home to pay your creditors, but they will give you the exemption value and any remaining funds go to the creditors. Now, mortgage and payments. If you're current on your mortgage and continue making your payments, you're generally allowed to keep your home, even in Chapter 7. However, if you're behind in your mortgage payments, bankruptcy does not automatically wipe out your mortgage debt, since it's considered a secured debt, and you could still face foreclosure. In summary, for Chapter 7, if you have significant equity in your home above your state's exemption limits, the trustee may sell your home. If you have little or no equity or are current on your payments, you may be able to keep your home. Bankruptcy doesn't automatically wipe out your mortgage, so you must continue making mortgage payments if you want to keep your home. Now let's take a look at Chapter 13. In Chapter 13 bankruptcy, also known as reorganization bankruptcy, is designed for individuals with regular income who can afford to repay some or all of their debts over time. In Chapter 13, you create a repayment plan to pay off your debts over 3 to 5 years while keeping your property, including your home, as long as you make the required payments. Now, can you keep your home? Yes. Chapter 13 offers more flexibility when it comes to keeping your home, even if you're behind in your mortgage or struggling with payments. Now, missed mortgage payments. One of the significant advantages of Chapter 13 is that it allows you to catch up on overdue mortgage payments. So if you're behind in your mortgage, Chapter 13 allows you to include missed mortgage payments in your repayment plan, which will pay off over the course of 3 to 5 year repayment period. As long as you keep up with the plan, you can avoid foreclosure and keep your home. The mortgage arrears. Chapter 13 can help you spread out any overdue payments over the life of the plan, even if you're in danger of foreclosure. Filing for Chapter 13 can stop the foreclosure process and give you time to catch up on the missed payments. No sale of the property. And like Chapter 7, there's no risk of losing your home in Chapter 13 as long as you continue to make the payments under the plan. If you're behind on the payments, Chapter 13 gives you the opportunity to get caught up without losing your house. So in summary, for Chapter 13, you can keep your home even if you're behind in payments, as long as you stick to the repayment plan. Chapter 13 is often a good option if you're struggling with mortgage arrears or facing foreclosure. Unlike Chapter 7, there is no risk of your home being sold to pay creditors as long as you adhere to the repayment plan. So, what factors will affect you whether you keep your home? Regardless of whether you file Chapter 7 or Chapter 13, the following factors will play a role in whether you keep your home. Number one, the equity in your home. If you have significant equity in your home, especially above exemption limits, it's more likely that the trustee in Chapter 7 bankruptcy will sell your home to pay creditors. In Chapter 13, your home is typically protected, but the equity will still need to be considered in your repayment plan. Number two, mortgage status. If you're current on your mortgage payment, you're generally safe in both Chapter 7 and Chapter 13. If you're behind, Chapter 13 may offer you more protection, and it allows you to catch up on missed payments. Number three, the state exemption laws. The laws in your state about home exemptions will directly affect whether you can keep your home. Some states have more generous exemptions than others, which can protect more of your home's value. And last, your repayment ability. In Chapter 13, you must show that you can afford the repayment plan, which includes your mortgage payments. If you can't afford the plan, or you continue making payments on your mortgage, you may still lose your home. But Chapter 13 offers a chance to work with your creditor to avoid the situation. In conclusion, whether or not you can keep your home depends on a variety of factors, including which chapter of bankruptcy you file, the value of your home, whether you're current on your mortgage payments. Chapter 7 may allow you to keep your home if you have little or are current on payments, but if your home value exceeds the exemptions, the trustee may sell it. And Chapter 13 allows you to keep your home even if you're behind the payments, as long as you can catch up through your repayment plan. It's always a good idea to consult with a good bankruptcy attorney who can help you understand your specific situation, which will be handled under the laws of your state. They can guide you through the process and help you make the best decision for your financial future while protecting your home.
Oh, and what a great detailed breakdown and of your various options. So obviously, if you're a person who's considering bankruptcy, you want to keep your home. So thank you for explaining all of that. I do have a follow-up question. I'm curious, you said something about household or homestead exemptions. And I would love for you to break down how homestead exemptions work and how they can help protect your home equity.
A homestead exemption is a legal provision that allows homeowners to protect a portion of the equity in their primary residence from creditors, including in cases of bankruptcy or other financial distress. The homestead exemption varies by state and can be a valuable tool for people trying to keep their home during challenging financial times, especially if they're facing debt collection, foreclosure, or bankruptcy. Here's how homestead exemptions work and how they can help protect your home equity. A homestead exemption is a provision under state law that protects a specific amount of the value of your primary residence from being seized by creditors to satisfy outstanding debt. In simple terms, it means that a portion of the equity in your home is exempt from liquidation if you file for bankruptcy or face other legal claims from creditors. The exemption amount can vary significantly depending on the state where you live. Some states have a set dollar amount, while others allow homeowners to protect the full value of their home up to a certain amount, as long as the property qualifies as their primary residence. Now, how do homestead exemptions protect home equity? If you file for bankruptcy, particularly Chapter 7, one of the main goals is to discharge your debts by liquidating or selling non-exempt assets to pay creditors. However, most states allow homeowners to exempt a certain amount of equity in their primary residence. This means that the equity in your home is less than or equal to the homestead exemption limit, you may be able to keep your home even if you file for bankruptcy. Let's give you an example. If you live in a state with a homestead exemption of $100,000, and your home has $80,000 in equity, you can keep your home because the equity is below the exemption limit. If your home's equity exceeds the homestead exemption limit, let's say you have $150,000 in equity, but the exemption is only $100,000, the trustee in a Chapter 7 bankruptcy might sell your home to pay your creditors. However, they will only take the equity amount above the exemption limit. So in this particular case, you would still receive the exempt portion of $100,000 and the rest would go to creditors. In Chapter 13 bankruptcy, the homestead exemption can also play a crucial role. While your home isn't sold in Chapter 13, since you're working with creditors on a repayment plan, your equity in the home is used to determine the value of your repayment plan. The homestead exemption can help ensure that you don't need to pay creditors more than the value of the exempt portion of your home's equity. So there's variations. Each state has variations in homestead exemptions. The specific amount of equity you can protect depends entirely on your state's laws. Let's look at a homestead exemption work in two different types of states. States with fixed dollar amount exemptions and states with fixed dollar amount exemptions, the exemptions amount is set as a specific value. For example, in California, the exemption depends on your age, marital status, and whether you have dependents. But it can range from $75,000 to $700,000 in equity. In Texas, Texas has a generous homestead exemption, allowing homeowners to protect the full range of their primary residence with no upper limit, as long as the property is under 10 acres in an urban area or 100 acres in a rural area. These states generally allow homeowners to protect a defined amount of their home's equity, regardless of the total value of the home. States with wildcard exemptions. Some states also offer a wildcard exemption, which allows a homeowner to apply a portion of the homestead exemption to any property, including home equity. For example, in Florida offers a full homestead exemption with no dollar limit on a home's value, but it also has specific conditions regarding the size and location of the property. It's generally considered one of the most protected states when it comes to homestead exemptions. These exemptions can be strong safeguard for homeowners, particularly those in states that offer higher or unlimited protection. So make sure that you understand that the homestead exemption is a powerful tool, and it's a powerful tool that must be used in bankruptcy. A homestead exemption is a powerful tool that can protect your home equity from creditors, including bankruptcy proceedings. Depending on your state, this exemption may allow you to shield a significant amount or even all of your home's equity, enabling you to keep your home in the event of financial hardship. However, the specific protection you get from the exemption depends on where you live, and the value of your property. Before filing for bankruptcy or making any major decision about your home, it is important to consult with a bankruptcy attorney who can help you understand how your state's homestead exemption law applies to your situation. They can guide you through the process and help you preserve your home while navigating your financial challenges.
Yeah, what a great answer. Yeah, I think most of us out here listening probably didn't even know that a homestead exemption was a thing. So to your point, learn about it, talk with an expert. It's a powerful tool you can use. So thank you for that. I do want to ask you, what happens if you just want to simply walk away from your home? Is that an option in bankruptcy?
Yes. Walking away from your home is an option in bankruptcy, but it comes with important considerations. Whether you're facing foreclosure, overwhelmed by your mortgage payments, or simply unable to keep your home due to financial hardship, bankruptcy can provide a structured way to walk away from your home without the consequences you might face outside of bankruptcy. The process of walking away from your home typically involves surrendering the property, which means voluntarily giving up your claim to the home. This decision can be part of either a Chapter 7 or Chapter 13 bankruptcy, but the way it plays out differs between the two chapters. Let's take a closer look at what happens in each case. Walking away from your home in a Chapter 7 bankruptcy, as you know, Chapter 7 bankruptcy is often called liquidation. The reason why it is because it allows you to discharge most of your unsecured debts. In this chapter, your non-exempt assets, if any, may be liquidated to pay your creditors. If you want to walk away from your home and avoid foreclosure, surrendering the property is a straightforward option in Chapter 7. Bankruptcy acts as the automatic stay and foreclosure. When you file for Chapter 7, an automatic stay is in place on most collections, including foreclosure. This immediately halts any foreclosure proceedings temporarily. It gives you some breathing room, usually a few months, while you figure out what you want to do with your home. And 2, you can surrender your home. If you decide that you no longer want to keep your home, you can surrender it to the lender as part of the bankruptcy process. That means you voluntarily give up your interest in the property, and the lender is free to foreclose or take possession of it. By surrendering the home in Chapter 7, you avoid having to continue making mortgage payments, and the home will typically be sold to pay off the mortgage lender. However, any deficiency balance, the amount that you owe after the home is sold for less than the mortgage, may not be discharged in Chapter 7 bankruptcy unless it qualifies under certain circumstances. For example, in the case of a second mortgage that is entirely unsecured. Third, what's the impact on your credit and the debt? Surrendering the property will likely lead to foreclosure, which will be reflected on your credit report. However, because you voluntarily give up your home as its debt, you won't be liable for the deficiency balance unless you sign the deficiency waiver or the lender pursues a deficiency judgment. In the long term, this may give you the ability to start rebuilding your credit sooner since you are no longer tied to the mortgage. No ongoing mortgage liability. If the mortgage debt is discharged in your Chapter 7 bankruptcy, it's an unsecured second mortgage or a home equity loan, you no longer will be liable for any of the debt. So if the debt remains secured, like the first mortgage, the lender can proceed with the foreclosure, but they won't be able to seek additional payment from you once the bankruptcy is completed. Now, it's a little bit different when you're walking away from your home in Chapter 13. Under Chapter 13, it allows you to keep your property while repaying some or all of the debts through a structured repayment plan over a 3 to 5 year period. However, surrendering your home is also an option in Chapter 13, especially if you're keeping the home is no longer financially feasible. Chapter 13 filing is like an automatic stay. Just like in Chapter 7, filing for Chapter 13 provides an automatic stay which stops foreclosure proceedings immediately. This protection gives you time to catch up on mortgage payments or decide if you want to surrender the property. 2, surrendering the property. If you decide that you no longer want to keep your home, you can surrender the property as part of the Chapter 13 bankruptcy plan. The process of surrendering in Chapter 13 is similar to Chapter 7 in that it involves giving up your ownership of the property, and the lender is allowed to foreclose and sell the home. Discharge of your mortgage debt. If you surrender your home in Chapter 13, any remaining mortgage debt after the house is sold, it's known as a deficiency balance, may be discharged as part of your bankruptcy, even if the home sells for less than what is owed. This is one key advantage of Chapter 13 over Chapter 7, where the deficiency balance may not be fully discharged depending on the specifics of the loan. Now, the impact on repayment plan. If you're behind on mortgage payments and don't want to keep the home, surrendering the property can relieve you from having to include these payments in your Chapter 13 repayment plan. This can lower the overall debt obligations. You don't have to pay. You don't have to pay it anymore. You don't have to address it on the loan. You don't have to address it under the plan. You can avoid the deficiency judgment. A key benefit of surrendering your home in Chapter 13 is that, unlike in Chapter 7, you may avoid a deficiency judgment because the bankruptcy court discharges the remaining debt once the foreclosure is completed. The lender is not able to pursue you for any outstanding mortgage payments or balances beyond the sale of the home. Other considerations when you walk away from your home is the tax consequences. If you surrender your home and there's a deficiency balance, the lender may forgive the balance. IRS may treat this forgiveness as debt, as income. Also, there's an impact on your credit score. Whether you surrender your home in Chapter 7 or 13, both options will have a negative impact on your credit score. A foreclosure will appear on your credit report, and it can stay there for 7 years, significantly lowering your credit score. Also, emotional and practical consideration. Walking away from your home can be it's an emotionally difficult decision, particularly if it's a place where sentimental value or where you live for a long time. It's important to weigh the emotions. It's important to weigh the emotions or the toll of leaving your home against the financial benefits of moving on and getting a fresh start.
Andrew, it's been great. There's so much good information. I have so many more questions to ask. We've got to wrap it up for time for this episode. So you know what? We'll have you back on and we'll pick up the conversation again. Thank you so much for being on today.
Oh, it was my pleasure. Thank you again. Anytime you want me.
Absolutely. And to our listeners, thank you for tuning into Bankruptcy Unlocked, your legal path to relief, featuring Andrew Griffin. If you want to connect with Andrew, visit andrewgriffinlawoffice.com and be sure to like, subscribe, and leave a review. And with that, have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.